Can I get 4 years in prison for failing to appear at one court date for a DUI or other criminal offense? I'm Gordon Thompson, DUI and criminal attorney for 46 years. Failure to appear for a court date for a DUI or other criminal offense is a crime. If the offense is a misdemeanor, then the failure to appear is a misdemeanor. However, if the offense is a felony, then it's a Class 5 felony. Arizona can be very harsh for DUI and criminal offenses, as a defendant in a rural county recently found out in the case of State versus DeFoya. That defendant was personally served with a summons to appear at an arraignment on a felony charge. He did not appear, and the court issued a warrant. That very same day, the county attorney filed a felony failure to appear charge. The county attorney also filed an allegation of prior convictions, stating that the defendant had at least 2 prior felony convictions. The effect of that filing is to eliminate probation as a possible sentence if guilty and make prison mandatory. The county attorney was not required to file that allegation. 1 week later, a police officer arrested the defendant. The failure to appear charge went to trial, and a jury returned a guilty verdict. The court then sentenced the defendant to the mandatory minimum prison sentence for a Class 5 with 2 prior felony convictions, namely 4 years. It is important to note that the defendant was convicted and sentenced to 4 years in state prison for the act of not appearing at exactly one court date. That date was for a preliminary matter and not something more important like a jury trial. It would have been easy to simply find and arrest the defendant on the original charges and hold him in custody until trial. The defendant had been personally served with a summons, and so the police had some idea where to find him, and in fact, he was arrested 1 week later. It is also important to note that for this 4-year prison sentence, it will cost the Arizona taxpayers over $150,000 to incarcerate him. That could have been zero if the allegation had not been filed and probation were available as a sentence. Lastly, from public court records, it appears the defendant was found not guilty of the most serious of the original charges.